JC 12867, Robert Murchison and another, v. Sherborn Zoning Board of Appeals and others.
Mr. Murphy, good morning.
Good morning, Mr. Chief Justice and members of the panel. May it please the court, James Murphy for the plaintiff's appellants. From the Dwyer case, crowding of an abutter's residential property by violation of the density provisions of the zoning bylaw will generally constitute harm sufficiently perceptible and personal to qualify the abutter as aggrieved and thereby confer standing to maintain a zoning appeal. This case followed that general standard. The assessment of what is permitted as of right and the change in the status quo as it relates to the aggrieved claimant is the way to look at this. It is not a per se standard.
Now, the amicus and your adversary, and I guess also Judge Foster, say what happened here was a conflation of the difference between the possibility of a violation and the question of whether or not, even if there were a violation, there's sufficient injury to obtain standing. What do you claim? I mean, you agree that there needs to be sufficient injury for standing, even if you're right about the width issue, correct?
It's plain that there are two parts to the standing adequacy analysis, one part being whether or not there's a legally cognizable interest, which I think everyone concedes, and secondly, whether or not there is particularized harm. Now, naturally, when in fact there's a density case, there's going to be some density-related harm. In this case, what you have, and in this case almost in particular you have, is you have a situation in which what exists as the status quo is a vacant lot. And what is going to be the status quo ante is going to be a house on that vacant lot. And that house is going to be across the street from this abutter. And that house is going to reduce privacy and open space.
So doesn't that mean you always win if you have a density claim?
In a build or no build case, generally you will win. There will be a high probability of standing in those type of cases.
So when you say win, in answer to Justice Budd's question, do you just mean standing or the whole case?
Oh, no, it's definitely just the standing question. That just takes you through the gate.
Okay,
Once
but
don't
you have to look at whether it's de minimis or not? I mean, isn't the judge, don't you have to have some kind of showing? And if the judge says it's de minimis.
Well, I think the cases are the standard that you have to put forth. If, in fact, your presumption of standing has been rebutted, which in this case we claim it has not. If that had been rebutted, then the proper standard is whether or not we have put forth credible evidence to substantiate the allegations. That's the standard.
So, I mean, it seems to me, though, that by virtue of being an abutter, is you have a presumed standing, right?
Say that again.
By virtue of being an abutter, just by virtue of being an abutter, you have a presumed standing, right?
By virtue of being an abutter, you have presumed standing.
And you're
Yes,
saying
sir.
that that was never rebutted?
The Section B of our
Nothing to do with density. That just has to do with the fact that you were an abutter.
So we have two arguments here, Your Honor. The primary argument in the Section A of our brief was that if, in fact, there is some sense that the defendants rebutted the presumption of standing, then we say, nonetheless, we have put forth credible evidence to substantiate our allegations. That's the Section A part of our brief. The Section B part of our brief, which could be a much narrower ground for this court to find in our favor, is that the presumed standing that we had was not rebutted at trial. And in particular, what we say about that is that there are some facts that they're not capable of being rebutted. So then going back to what Justice Budd has talked about, there in some of these cases, like this one, for standing, there are going to be some unrebuttable facts that will then confer standing on
House or no-
abutters like mine.
Building or no building, that's your point of view, right?
That, on this one, building and no building, I think, are clear. So, for example, all of the cases that were cited by the defendants that they want the court to instead look at.
But that's gotta be wrong. I mean, you don't get to prevent someone from building on a buildable lot.
Well, the question is whether or not it's a I think it's clear in Sherborn, okay? What Sherborn says is that every lot shall conform to the dimensional requirements, and if it does, no building shall be built which does not conform to such dimensional requirements. So if you violate those dimensional requirements, you cannot build a house. And so in these type of cases, which are building permit cases, they're not variance cases, they're not special permit cases.
Again, you're falling into what Judge Foster says, which is that every time you claim that there's a zoning violation and you're an abutter, you have standing.
No.
And that's a revolutionary departure from the way this has been interpreted in the past.
No, I can give you examples as it relates to all of these cases.
And let me just, you're talking about an invasion of privacy, right? What is the other one? You're
Open space.
I mean, you're 180 feet. That's an NFL kickoff almost away from your neighbor. That's completely different than the cases you cite where literally the building is looming over it's 14 feet away in Shepherd. It's very close to the other. I mean, this is a radical change in the law, isn't it?
No, it is in no way a radical change, Your Honor. So let me just start with Dwyer. In Dwyer, the situation was that the builder was seeking to put two houses behind Dwyer's house, and they had 40,000 square foot lots. And they said in that situation, no, he's only entitled to one house, not two houses. And in
that case, they were already exceeding. There were violations of density already, right?
No, I don't think, when you look closely at the case, I think the inference that they were taking was that they were previously existing non-conforming lots.
Right.
And so that was, I think, really the context of that. But what happens here is what is the agreement that the town in its zoning makes with its residents? And Sherborn makes the agreement that you're going to have 3-acre lots. They're not the Cape, we're not Boston, and so for Sherborn, that is what the standard is. There is a specific dimensional requirement that you cannot build there.
But they get to decide. I mean, there's deference that we owe to the zoning board of appeals as it relates to their own zoning, and the dimensional requirements, the width. They are entitled to some deference for
Now,
that.
deference is in the substantive case, Your Honor. On this one, on the standing, there's not an issue of whether or not the substantive issue is whether or not there was adequate lot width. That is the case. That part is not decided. And on deference, if we get to the substantive case, the deference is eliminated in those situations in which there's a statutory interpretation. So, for example, in Perullo versus Croft, which is a case that's in the substantive realm, in that case, the question was whether or not there was adequate lot depth. And in that situation, although the local zoning board had decided that they were going to give deference to, they were going to permit there to be adequate lot depth, when it went to the appeals court said, no, you cannot interpret lot depth in that manner, and we will not give you deference, local board, in that situation. So deference is really the issue on the substantive case, not on the gatekeeping standing part of the case. And so, and if I could go back, in the Marhefka case, so that was a case in which it was in Sutton, and the lots were 80,000 square feet. And in that case, the adequate proof of individualized harm was a loss of a pond view, that they had the right to see through open space. And by building a structure, even though it was 80,000 square foot lots, that was going to be a particularized individual harm that gave them standing. And all,
So losing your view of your pond was deemed standing in that case.
if in fact what was going to happen was that you were going to build a structure that you could not otherwise build. And that's why,
Again, describe the particularized injury that because your client isn't being deprived of a view, right? You're describing a house being built on this lot, but that house is, again, 180 feet away from you. Your views are focused the other way, from what I understand. So tell me, what's the particularized injury? Because I think that's what's got the land court animated, in that the violation doesn't have any real injurious effect on you.
okay, first, factually, it's not true. If you look at the...
Don't let me misstate the facts, so definitely correct me.
Okay, so there is not evidence in the record that the house that he accepted the question that his house was oriented towards Farm Pond. He said specifically no, he had views on all four sides of the house, and so that the reference in the record that's what the correct reference is in the record. So he says he has views on all sides, and he says that what's happening is that this is going to decrease his privacy, because now there's going to be an extra house built there that isn't there now.
Right,
and
but
that's
again, let me just push that a little bit.
Yeah.
So let me compare it to the Shepherd case. Shepherd case, literally the house is 14 feet away and the person is looking into their kitchen. You're 100, again, and I have trouble visualizing 180 feet, but it's like, it's 60 yards away, right? So you're looking, how is that interfering with your privacy when it's that far away?
Okay, so the record is, Your Honor, that in Sherborn, privacy is valued.
I get
And that
it.
these large lot sizes are important elements of what Sherborn's character is. It's rural character, and in fact, you're putting something in that view.
So the fact that you can see it, but you would have that would have the same impact if it didn't violate that, I can't remember what we're talking about, the width.
Lot width, Your Honor.
You would, even if it were built within the lot width, if it were skinnier, you would still see it, right?
Then we would not be able to succeed in this.
Wouldn't succeed on the merits, but you would still have the same problem on the, you would still see that house, and to you, that's enough, isn't it?
No, because you need the legally cognizable interest, and in that situation, you would not have a violation of the density provisions of the bylaw. So since you have if you had as of right to build it, they can build it. I don't care whether or not it's right up to you. If you're in Boston next to Shepherd, and that house goes up right next to you, and that's as of right, you don't have a claim to bring forward. And so in each of the cases, as I was trying to get to, Your Honor, in each of the cases that are cited by them.
Again, let me just, so I understand they wouldn't have the right to build it if it were as of right. I mean, they would have the right as of right, but the impact on you is no different. Isn't that what the land court is focusing on, is that you can't identify any difference between, I mean, it's an illusory or de minimis injury when we're talking about the difference here when you're 180 feet away from that building, right?
I don't think it's different at all.
Describe how the fact that is it because it's 3 feet closer? Is that what makes it different?
No, I don't think there's any relationship at all to the amount of feet, Your Honor, to the amount of the imposition. I think that's all driven by the local bylaw. So it's going to be different at the Cape, it's going to be different in Boston, it's going to be in Sherborn, it's going to be different.
So you're saying the bylaw here is what's driving this, because I know Justice Rubin said the bylaw was density related. Do you agree that that's what this turns on?
Well, I don't think it turns on it. I think that what happens is that you have the provisions of the Enabling Act, and then you have the specific provisions that are contained in Sherborn zoning bylaw section 4.2, And it says, as a basic requirement, that every lot shall conform to that dimensional requirement, and no building or structure in any district shall be built, located, enlarged, or structurally altered, which does not conform to those dimensional requirements, and that's at
Right,
677.
but aren't you, this goes back to the issue, let's assume there is a violation of the width limits. The standing principle essentially says, if it's de minimis, we don't care. We're not going to let you use our courts and hold up and cause expense if the fact of the matter is that the violation produces de minimis injury to you. Agreed?
I don't think that that is a proper analysis for this case,
It's a-
because we
well,
don't have a
I'm sorry,
situation in which we're
which
relying
part is
upon-
it? Which part is improper? The standard I set or the characterization of, which I haven't yet, as de minimis?
I think the characterization of de minimis as it relates to a build versus build is completely wrong. If in fact it was, for example, if someone says noise or traffic, then that has the potential, if in fact they put in evidence on the defendant's side, they bring forth affirmative evidence, then in that circumstance, the court could find that, okay, on noise and traffic, now that your presumption has been rebutted, I find that any damage that you had allegedly suffered was de minimis as it relates to noise or traffic.
Well,
But that is
didn't
not
the
the same
land
whatsoever
court-
at all with
Didn't the
respect
land
to.
court find that they will not be actually harmed?
No, Your Honor. I think if you look at the land court decision, the very interesting part of the land court decision is that it's broken into three kind of sections. One section is broken into diminution of value, the other one is the stormwater, and then the third is this grouping of all other factors. So on diminution of value, it's plain that what you had was that they had somebody that they proffered as an expert, and so that they rebutted the presumption on that issue. On stormwater, they had an expert and we had an expert, so at least the presumption went away on stormwater, and then we were back to whether or not we had put forth credible evidence to substantiate the allegations. Not that we had succeeded, but credible evidence to substantiate the allegations. And then what the court did is that it based all of its other things based on the fact that it said it didn't necessarily believe Mr. Murchison. There was no affirmative evidence put in on any of those issues, and those by the defendants in that case, so that's why we say that they hadn't rebutted it at that one. But even if they had, by saying that they didn't believe Murchison, so that's not enough evidence on this side, on the plaintiff's side, that was only as it related to the noise and the traffic. But as it related to the other facts were unrebutted and could not be rebutted, which were the distances, the fact that there was going to be a house where there formerly was not a house, that there was going to be a reduction of the open space, and that there was going to be a reduction of the privacy.
Oh, wait a second,
And-
wait a second.
Say that again?
I didn't say anything yet. I said, wait a second, please. What I was saying was, now what I wanted to say is that I'm looking at these pictures, and it seems to me that there are two houses already there. It's going to be built between 172 and 180 Lake Street, right? It's not like this is like this wilderness area. It's been cleared, as a matter of fact, right?
So the evidence in the case, Your Honor, was that one of those houses was approximately 600 feet away, and the other house was approximately 240 feet away. The other evidence in the case was basically,
So the judge also took a view, right?
the judge did take a view, did not go inside the plaintiff's home, and the judge did not make any specific findings based on that view in the decision. So although they took a view, there were no affirmative findings made based on that view in this case.
Well, you're not arguing, are you, that there aren't already two houses already that are nearby, right?
Say that again, Your
You're
Honor?
not arguing about the existence of those two houses, right?
No, those two houses that
And they're
were-
across the street from
Those two houses were built as of right with adequate lot width and adequate frontage, and they are as of right houses, and we have no claim against those houses. Now, what happens is this lot that's in the middle is traded back and forth between the house on the left and the house on the right, and that house in the middle, it's the bulk of it is only 200 foot wide. The bottom of it has a little bit more of a width. But if you look at the actual lot itself, it's got 200 feet. This is a gerrymandered lot. They're trying to squeeze a third house onto that gerrymandered lot.
That goes to the issue of whether there's a violation. Does not go to the issue of injury. So help me in your last, you're already over your time, but help me to understand. The best I can tell is the injury you cite is that your client standing on the 40-yard line from his garage, not even from his home, but from his garage, would prefer not to see a house on the goal line, not the nearest goal line, but the furthest goal line, 60 yards away. That's the injury you cite is that your client would prefer that there not be a house there at least 60 yards away. Is there more than that I'm missing?
There is more that you're missing. First of all, Your Honor, the facts of the house facts were that his office is right there, also where that garage happens to be.
So it's from his office. Okay,
And so he's there all the time. And secondly, the question is, for purposes of evaluating harm, is what was the status quo before and what will be the status quo after? Before, there is no house there. He has a complete unobstructed view and privacy from that lot that's looming over his house, that's 20 foot higher in topography from where he is, and that he has that benefit of that open space and that privacy, and that's what he bargained for when he came into Sherborn and got 3-acre zoning. And to squeeze another house into that 200-foot window where no house should go is particularized harm to the plaintiff
The lot's
appellants.
3 acres though, right? That's not in dispute.
The lot is 3 acres, but if you look, you'll see that they just squeeze it in at three acres, yes.
They squeeze it in on 3 acres.
Yes, Your Honor.
Okay.
Thank you very much.